Thank you very much for joining us. Welcome to Landmark Chambers, RSK Biocensus and Walker Morris's webinar on A Green Brexit, Removing Red Tape or Increasing Environmental Protections. I'm really pleased to see so many of you joining the session today, and I hope that you'll find the presentations and the discussions to be really useful and informative. My name is Stephanie Wray, and I'm a director at RSK Biocensus and Nature Positive, and I'll be chairing the session today, joined by my colleagues Alison Ogley, who's a partner at Walker Morris, and James Maurici QC, who's a barrister at Landmark Chambers. And I'll introduce them properly in a moment. We'll each speak for around 20 minutes or so, and then there'll be time for your questions at the end. To begin with, though, there's just a few housekeeping points to note. Much simpler in these times of virtual meetings, as I'm sure you all know, the locations of your own bathroom and kettle. So your microphones are all muted automatically, so you don't need to adjust your local settings at all. We'd be very happy to take your questions throughout the session, so if you can submit them via the Q&A box, which should appear at the bottom of your screen. We'll try to answer as many of the questions as we can at the end of the session. The webinar is being recorded, and you'll receive a link to the presentation and the recording shortly after the end of the event today. If your connection is lost at any point during the webinar, you can simply rejoin the meeting by clicking on the original link. That should work. If we lose our connection to the webinar, then we'll make it up as we go along, and I'm sure we'll work something out. So let us begin then. So your speakers today, let me introduce you to your very eminent legal speakers this morning. There are two of them. James Maurici, first of all, was called to the Bar of England and Wales in 1996 and was appointed Queen's Counsel in 2013. He was also called to the Bar of Northern Ireland in 2009. James practices in planning, environmental law and public law, and his practice regularly encompasses EU and international law. James's planning practice covers all aspects, including advisory, advocacy at inquiries and hearings, and advocacy in the higher courts. His environmental law practice is similarly wide-ranging, covering matters such as habitats and species protection, contaminated land, air quality, waste, access to environmental information, statutory and common law nuisance, all aspects of environmental impact assessment, strategic environmental assessment, environmental permitting, climate change issues, and emissions trading. And I'm beginning to wonder what I've been doing with my life. James has made many appearances before the Court of Justice of the European Union and the Environmental Court of the European Union in environmental cases. Chambers and Partners recommends James as a leading silk for environmental matters, describing him as an intellectual powerhouse and one of the best advocates at the Environment Bar. Legal 500 describes him as the go-to man for anything really big. And since we can all agree that both Brexit and the environment are genuinely very big, then, ladies and gentlemen, we've definitely found ourselves the right man for the job this morning. Our second speaker today is Alison Ogley, a partner at Walker Morris in the firm's planning and environment team. Alison is dual qualified, having previously practiced as a barrister at King's Chambers. As an experienced advocate, Alison provides combined advocacy and litigation services in high court cases, including judicial review and Section 288 challenges, in addition to her established public inquiry practice. Alison specialises in advising clients in all areas of planning and environment law and has acted on a variety of major development projects, including housing, minerals, waste, retail, and renewable energy. Her experience allows her to provide valuable strategic advice to clients from the inception of projects through to securing permissions for developments at planning appeal, and thereafter representing clients in any subsequent High Court proceedings. Legal 500 describes Alison as particularly skilled in contentious environmental issues, and she's name-checked in Chambers and Partners and recommended for specialisms in biodiversity cases and policy matters, which luckily is exactly what she'll be talking to us about this morning. Finally then, me. In stark contrast to these legal high flyers, my background is as an ecologist, and I specialise in assessing the impacts of human activities on nature and all the wonderful complexity that that involves. I'm here this morning to give the view of the welly-clad environmental practitioner, although in the interests of full disclosure, these days I do spend rather more time waving my arms around in boardrooms than actually out in the field. I do that because, never having found any job that was looking for someone with a PhD in ecology and an MBA, I've recently founded a startup company, Nature Positive, within the RSK group, and we work with corporate and investor clients to help them understand their impacts and dependencies on the natural environment, to de-risk their operations and leave a net positive legacy. And that, ladies and gentlemen, is your panel this morning. So with no further ado, I'd like to hand over, if I may, to James, who's going to speak to us about Brexit and the Environment Bill, an opportunity for the rolling back of EU environmental laws. Thank you, James.
Good morning, everyone, and thank you, Stephanie, for that introduction. What I'm going to be talking to you about today is whether the Brexit effectively provides an opportunity for the rolling back of EU environmental laws. And that's involved me doing some thinking about where we've been, what the constants have been in environmental law for a very long time now, and where we're heading. So obviously, since 1973, the provisions of the EU treaties, which have increasingly over the years had environmental provisions and principles within them, and the vast amount of EU legislation in the form of directives, regulations, decisions, and other soft law measures, they've been a constant feature of our environmental law, indeed a dominant feature of our environmental law. And some of the sort of most well-established pieces of that law, the EIA directive we've had since 85, Habitat since 92, the Birds directive since 79, and Waste indeed since 75, and even SEA now, nearly 20 years old, all constants that we've become very used to. And whatever the legal claims that have been brought relying on that law, including those brought by what some people in the government might call activist lawyers, and however much the requirements of the treaty or legislation have derailed schemes that the government would very much like to have seen happen, they were stuck with it. There was nothing they could do about this legislation. And I would just contrast that with, take a piece of legislation that's got nothing to do with the EU, the Climate Change Act. The Climate Change Act of 2008, been with us for 12 years, not much used in litigation. There have been some cases recently, but not many. And one thought that's certainly been articulated to me by others is that NGOs were nervous about using legislation to attack the government, where that legislation could then be changed by the government of the day, which of course was not true for any European law. You could use it at will and there was no risk the government would change it. And of course, that's what potentially is all changing now. In addition, of course, we've been very much having to adhere to the jurisprudence of the European Court. It's been another constant. And however lacking in common sense or wrong-headed those decisions have been thought to be by the government or by our courts or by us as practitioners, we've not been able to depart from them, distinguish them, but not depart from them. And that is really all about to change. So you'll all know the famous quote from, I think, Bulmer and Bullinger, I think, was probably the first case that dealt with European law after we joined, and certainly the first to go to the Court of Appeal. Nothing to do with the environment. It was actually to do with whether you could call certain forms of cider and pear cider champagne, which you couldn't once we joined the EU. But Lord Denning famously said that EU law, EC law as it was then, was like an incoming tide flowing into the estuaries and up the rivers, and it cannot be held back. And Parliament has decreed the treaty is henceforth to be part of our law. It has equal force to any statute. Of course, as things turned out, it ended up having rather more force than any other statute. And Lord Denning later expressed himself more forcibly, extrajudicially, that he said it was no longer an incoming tide, but a tidal wave that was bringing the whole thing down. And of course, what we're now faced with is potentially an attempt to reverse that tide, which is a mammoth task. Now, following the implementation period, so that's from the 1st of January next year, there are four things which I think are important. One is that the environmental principles that we derive from the treaties, the precautionary principle, the preventative principle, the polluter pays principle, etc., will no longer be a binding and applicable part of our law via EU law. Secondly, the UK government, and indeed the devolved governments, can legislate to depart from pre-exit EU environmental legislation. And secondly, they're of course not required to transpose and adhere to any post-exit amendments to existing EU legislation or any new EU legislation. And then thirdly, the role of the Commission as an enforcer of environmental law ends. And then finally, there's no role anymore for the European Court in determining the law, and domestic courts are not bound by post-exit European Court case law. And indeed, and I'll come back to this in more detail because it's important, there is at least some ability for some courts to depart from pre-exit case law. So really there's three things in play. One is the loss of our established long-standing environmental principles that have come from the treaties, like the precautionary principle, but also the governance mechanisms. So the Commission, the European Court, they'll all be gone following Brexit. Secondly, we have a government's newfound ability to repeal and amend environmental legislation derived from EU legislation in a way that's simply been impossible up to now. And then thirdly, we have the ability of our own courts to take a different line to that taken by the European Court on environmental law, where that's derived from EU law. And I want to look at those three things in a bit more detail. So first of all, principles and governance. So I think there's a recognition by the government that Brexit creates a gap in terms of principles and governance. And one of the principal purposes of the Environment Bill. The bill and the explanatory notes to the bill specifically say there's the intention is to have no environmental governance gap when we withdraw from the EU. And that really, so far as we're concerned today, there's probably three elements to it. I mean, one is setting a number of long-term, legally binding, joined up environmental targets across a number of fields. Secondly, it's about replacing the environmental principles that disappear from the treaty. And thirdly, there's the creation of a new public body, the Office for Environmental Protection, to replace the role previously taken by the Commission. There are, I think it's fair to say, some mixed messages about principles and governance from this government. So under the earlier withdrawal agreement, the one that was not signed, there was a principle of non-regression in the draft protocol, that environmental controls post-Brexit would be at least as rigorous as those applicable in the EU. But this was removed from the final withdrawal agreement and protocol. Despite that, back in January of this year, which obviously seems like a lifetime ago now, the Environment Bill was said by the government in a policy statement to deliver on their commitment to have the most ambitious environmental programme of any country on earth, and was part of a wider government response to clear and scientific case and growing public demand for a step change in environmental protection and also in recovery. More recently, though, on the 30th of June, everyone will remember the Prime Minister's speech, time is money, and these newt counting delays in our system are a massive drag on productivity and prosperity. So we will build better and build greener, but we'll also build faster. And that's why they've set up the wonderfully named Project Speed to scythe through the red tape. We will, of course, build, build, build. And then, to similar effect, really, the Environment Secretary in July launching a consultation, it said in the autumn, on changing our approach to environmental assessment and mitigation in the planning system. And said, if we can front load the ecological considerations in the planning process, we can protect more of what is precious. We can set out which habitats and species will always be off limit, so everyone knows where they stand. Sounds wonderful. Obviously, in the real world, for anyone who actually understands these issues, that doesn't make a lot of sense as far as I can see. And then we've had the planning white paper. Again, build, build, build. So how do you reconcile these statements? I mean, are we looking at a government who is giving mixed messages, confused messages, surprising, I'm sure, given where we are on COVID, that we have a government that would be giving mixed messages. Well, I can't decipher where we're going. I think if Matt Lucas was trying to summarise it, doing an impression of Boris Johnson, I think this is what he would come up with. So we're saying we'll fully maintain EU environmental protection. This will be a green Brexit. But as all this EU-derived newt counting causes such huge delays, we'll also be slashing the red tape and allowing people to build as they like. So that's my summary of where we've got to, how that is reconciled in practicality, in the real world, in legislation, who knows. On principles and governance, there are really two things about the bill which we need to deal with before we can move on to my next topic. One is there's a requirement for a policy statement on the environmental principles. So the government must develop a policy statement, and this is for England, dealing with precautionary principle, polluter pays, etc. And due regard must be had to that policy statement on the environmental principles by a Minister of the Crown when making policy. And then the second big thing is the creation of the Office for Environmental Protection. And the question is, do these achieve equivalence with what we are losing from the EU? And the short answer is no. I haven't got time to go into the details. I've given you a cross-reference to a presentation by David Alison QC, who's looked at this in detail. But just taking for a moment the environmental principles, they will not apply directly. They will only apply through the policy statement. And they are only something to which ministers of the Crown, not other public authorities, must have regard to, not the same as what's being replaced. For the Office of Environmental Protection, it's a whole talk in itself as to why that isn't the same as the Commission. And I really haven't got the time, I'm afraid, to go into that, but happy to answer questions in due course. So that's the first topic, which is the loss of the principles, the loss of the governance. The second of the topics I identified at the beginning was the ability of the government, newfound ability, to repeal or amend environmental laws. So by way of introduction, only really in relation to this, obviously much of our environmental law legislation was enacted through Section 2.2 of the European Communities Act and will now be retained EU law, that is EU-derived domestic legislation, once we get past the implementation period. So this will include regulations like the EIA, SDA, habitats regulations, for example. And as I already mentioned, under the withdrawal agreement to sign, there's no non-regression provision. So there is nothing that stops, in international law terms, the government repealing or changing those laws. Some EU environmental law is required to be retained in the protocol in Northern Ireland, but not actually EIA, SCA and habitats. What is required to be kept is more around chemicals, waste and certain other environmental regulation. In any event, you'll have all seen the debate that's been going on about the Internal Markets Bill. Will the government in any event comply with the protocol? And of course, post the implementation period, the government is free to repeal or amend any of this retained law. And as I said, there's no obligation to transpose amendments to EU legislation that are made by the EU or any new EU environmental legislation. Just to give you one example, obviously we have the Conservation of Habitats and Species regs and the marine version. They transpose Habitats Directive and indeed Birds Directive, and those regulations or earlier versions of them have been with us since 1994. They've already been amended, both those sets of regulations, by the Conservation of Habitats and Species Amendment EU Exit Regulations 2019. Catchy title. And these come into force not actually until after the implementation period, so January 2021. What they actually do at the moment is make relatively minor changes. So for example, they remove references to Natura 2000, replace it with references to a UK network. They replace the references to the EU Commission in the provisions transposing Article 6.4. But it would be open for the government to make other changes as it sees fit in due course to those regulations that implement the directive. Can I then turn to the third topic, which is the courts? And I think in some ways, one of the most interesting, certainly from the legal perspective, obviously during the implementation period, decisions of the European Court continue to apply to the UK as if it was still a member. But after the implementation period, Section 6.1 of the Withdrawal Act 2018, as amended, provides that a court or tribunal is not bound by any principles laid down or any decisions made on or after IP completion day by the European Court. And of course, our courts cannot refer questions to the European Court after that date. In relation to the interpretation of EU-derived law in the UK after the implementation period, so law that we've retained but which derived from the EU, the Act says at 6.2 that a court or tribunal may have regard to anything done by the European Court or another EU institution on or after exit day, so far as it's relevant to any matter before them. So they can have regard to it, they're not bound by it if it's post-exit, but they can have regard to it, subject to the provisions of subsections 3 to 6. And I'm going to come to those in a moment. But before I do, I have to just introduce briefly retained case law. That's something defined by the Act. It includes retained domestic case law and retained EU case law. And you can see that basically it means principles laid down by and decisions of a court or tribunal in the UK or in the European Court, which had effect in EU law immediately before exit day. So this captures both European court decisions, but also domestic court decisions which have applied European law. So this is the important definition that we've got in relation. If we then go back to section 6.3.6.6, 3 says any question on validity, meaning, effect of any retained EU law is to be decided, so far as that law is unmodified on or after IP completion day, and so far as they are relevant to it, in accordance with any retained case law and any retained general principles of the EU law, and having regard to, amongst other things, the limits immediately before completion day of EU competences. But the Supreme Court is not bound by any retained EU case law. So it has the ability to depart from previous decisions of the European Court in relation to retained EU law. But in deciding whether to depart, the Supreme Court must follow the same test that it would apply in deciding to whether to depart from its own case law. So that takes us to the Practice Direction of 1966 and the case law, which was House of Lords case law, now applied in the Supreme Court, as to when the Supreme Court will depart from its own decisions. And obviously, generally it won't, but it can. It said it should be reticent before doing so. The court must be circumspect before accepting an invitation to depart from its own case law. That would now apply to retained case law. However, the courts have recognised you can't too rigidly adhere to that because it might lead to injustice and restrict the development of the law. Now, that's the Supreme Court, and it would mean, of course, that other courts below the Supreme Court were bound to carry on applying retained case law. But the 2020 Withdrawal Agreement Act introduced a power by delegated legislation for the government to legislate so that any other relevant court or tribunal is also not bound by retained EU case law. And they've got a power to make regulations to allow other courts to, like the Supreme Court, depart. It's an extremely wide enabling power. It has to be exercised before the end of the implementation period. So it's got a time limit to its use. But it allows the government to expand the range of courts that can depart from retained EU case law, to change the test that the courts would apply in deciding whether to depart. And it can also differentiate between the approach that the courts take to departing from decisions of the European Court or domestic court decisions which were founded on European court cases. Now, the government consulted earlier this year on extending the ability of courts to depart, and a response was published just last week. And the indication, as I understand it, is the government will now extend the ability to depart from retained EU case law to the Court of Appeal. The Court of Appeal will have to apply the same test as the Supreme Court does on whether to depart. But that does mean that from January, both the Court of Appeal and the Supreme Court will be able to depart from European court cases, but also domestic court cases, including Supreme Court cases, if those were themselves based on European law. We haven't seen the regulations, but that seems to be the proposal that the government now make. So why does this matter? Well, many people think that sometimes the CJEU case law has gone too far, and or it was wrongly decided. Certainly, I hold that view on some aspects of the law, which I'm going to come to. But of course, until now, there was nothing we could do about it. We had to live with those decisions, whether we loved them or hated them. And I want to look at 3 examples. So one is people over wind, which you'll all be familiar with. The second is habitats, the certainty test. How much certainty does one have to have on an appropriate assessment? And the third is a particular aspect of SEA law, which, if anyone's ever heard me speak on this before, will know this aspect of case law can make me very angry. So I'll try and restrain myself in terms of discussing this point. People over wind. Well, you know, look, prior to that decision, we had very well established domestic law that in undertaking the trigger or screening stage assessment in deciding whether there was likely significant effects, it was legitimate, lawful, and proper for the decision maker to take into account mitigation measures, which would prevent likely significant effects arising. For example, SANG. And we can go back to the wonderful cases like Hart and Smythe. And indeed, in Hart, what Mr. Justice Sullivan said was that it would have been ludicrous to disaggregate the different elements of the package and require an appropriate assessment on the basis that the residential component of the package considered without the SANGs will be likely to have a significant effect, only to have to reassemble the package when carrying out the appropriate assessment. And what the judge said was that the idea you can take into mitigation at the first stage was just common sense. Well, of course, what we know is the European Court in People Over Wind adopted an approach that was contrary to that common sense, and indeed was ludicrous, if we use the word that was used by Mr. Justice Sullivan to describe that approach. And our courts have been trying to wrestle with the consequences of that decision. See cases like Langton, Canterbury City Council. The decision in People Over Wind, as far as I'm concerned, is clearly and plainly wrong, and the decisions of the domestic courts were clearly and plainly right. We've not been able to do anything about that, but come January, we will be able to try and persuade the Court of Appeal and or the Supreme Court to depart from People Over Wind. And given the practical difficulties, the ludicrous nature of some of the results, I think you cannot rule out that even applying the 1966 practice direction type test for departing from case law, that this is something that could happen. And for my part, it will be no bad thing. The certainty test. Well, I mean, there are concerns that cases like Dutch nitrogen, but not just Dutch nitrogen, other cases have seen the European Court applying a requirement for certainty that gets higher and higher and higher and is simply too high and wholly impracticable. And in some senses, if that is what that case law is doing, and I have my doubts about whether that really is what Dutch nitrogen in those cases are doing, the language is unhelpful in places, but I question whether the European Court really was raising the certainty level beyond Wannsee. But if it was doing that, that doesn't fit with the domestic approach, for example, that articulated in Champion, which recognises the subjective nature of this process. And the courts have been trying to navigate around this potentially heightened certainty test in recent cases like Compton. Well, again, the Court of Appeal and the Supreme Court are going to be free, potentially, subject to the application of the correct test, of departing from this line of cases to the extent that they extol an ever impossible level of certainty required for the outcome of the appropriate assessment. And again, would that be a bad thing? I have my view, others may not agree. And finally, inter-environment Brussels. So the SEA directive has a clear exclusion from what it covers. It only covers plans or programs that are required by legislative, regulatory, or administrative provisions. So your plan or program can't be a voluntary one. It has to be something that you are required to have produced. And it's clear both from the words used in the legislation, but also from the travaux, so the preparatory documents that led to that legislation coming into force. And as the Advocate General explained brilliantly in her opinion in that case, this was a deliberate limitation that the EU legislator imposed. They wanted that limitation in place. What happens in inter-environmental Brussels? The European Court says, well, required doesn't actually mean required. It means regulated. So long as there is some legislation out there which governs some aspect of the process by which a plan or programme is made, that means required. So in other words, required doesn't mean required, it means something completely different. Why? Well, because the European Court said, well, look, the aim of this directive is to assess things. And if you apply this exclusion, you'll be excluding stuff from assessment. But of course, that is rather the purpose of an exclusion from scope. And it is an extraordinary, frankly, piece of reasoning by the European Court. And in the HS2 case in the Supreme Court looked at all of this, frankly, clearly thought that it was all wrong, which it obviously is. And they said, had it mattered in that case, they would have referred the matter back. So it was said by Lord Neuberger, the national courts faced with a clear legislative provision to which the fourth chamber of the European Court has, in the interest of a more complete regulation of environmental developments, so pausing there, I mean, acting almost like a legislator, given a meaning which the European legislature clearly did not intend. For this reason, we would, had it been necessary, have wished to refer the matter back to the European Court to ask them, I won't read it out, but basically, are you serious? Are you really serious about that? And of course, now our courts could depart. Believing that to be completely wrong, they could depart from it. And in my view, no bad thing in relation to that. So can I sort of bring this to an end? Two things. Conclusions. Many of the old certainties that we've had since 1973 have gone. EU-derived legislation can be amended by the government. We better get used to that. Amended or new EU legislation will not apply in the UK unless the UK chooses to apply it. The overarching environmental principles are gone, and the Environment Bill does not adequately replace them. There's no more EU Commission, and query whether the Office of Environmental Protection will fulfil that same role. The Supreme Court and the Court of Appeal, it seems, will be allowed to depart from pre-exit EU case law, and all our courts will be free not to follow post-exit European Court case law. Two other things. What might limit our departure from, our running away from EU legislation that's been in place for a long time? I guess one thing is international law. In the Environment Secretary's speech in July, he made the point, well, look, you know, the EU keeps getting heralded for doing these great flagship pieces of legislation like the Habitats Directive and the Birds Directive. But actually, they were just giving effect to international agreements that were already in place and which the EU are a member of. So that is a potential signal for international law having a bigger role in controlling and exercising control over our environmental legislation in this country. And you know, Plan B in the Court of Appeal obviously gave a heightened importance to an unincorporated international convention, although one must now read that in the light of the Court of Appeal's sort of rewriting of what they decided in Plan B in the Packham case. And Plan B itself is under appeal and may well be overturned. The other thing, of course, which may limit departure is any desire to keep pace with the EU, depending on what agreement we reach with them in terms of trade. And we know nothing about where that will go. The other issue, which I've talked about before, I've given you a reference to a previous talk I've done, is what the implications may be for divergence of environmental law within the UK, because we haven't got that constant now of all the EU law across the jurisdictions within the UK. There's much more room for different views to be taken about what legislation should be enforced between the countries of the United Kingdom. So that's everything I had to say. I'm going to hand over to Alison now.
Thanks, James. Absolutely fascinating. Thanks very much for that talk. One of the things that I'm going to pick up now is biodiversity net gain. It is one of the areas where the government's been relatively consistent about its intentions, unlike most other things at the moment, including Brexit, the general protection of the environment, and of course, COVID. So first of all, I'm just going to run through the origins of biodiversity net gain. I'm sure some of you will already be familiar with this, but the starting point in terms of the legal framework is the Natural Environment and Rural Communities Act. We've had that, it's been in force since 2006, but at that time, the duty, as it is today, until the Environment Bill comes into force, the duty was to conserve biodiversity. Now, the Environment Bill proposes to expand that existing duty so that it would be to conserve and enhance, and of course that gives an increased platform for biodiversity net gain. We've obviously also got the existing National Planning Policy Framework, paragraph 175A, and of course it recommends refusal if significant impacts on biodiversity can't be avoided, mitigated, or as a last resort compensated for. So that's where this has really been born out of. Some of you might remember back in 2011, the Natural Environment White Paper and the Lawton Review. And again, that was really the origin of offsetting the drive to try and join up our fragmented ecological habitat. That was one of the biggest things that the Lawton Review highlighted. And we'll see as we progress through that that's one of the issues that the government is trying to address through the Environment Bill. A little question posed at the end of that slide there. In terms of the current policy that we have in the framework, we've obviously got this mitigation hierarchy with the idea that compensation is the last resort. Now, that doesn't really apply rigidly in practice as it stands at the moment, but of course the opportunity for mandatory net gain might actually take away from that even further. So there might be a requirement to amend the National Planning Policy Framework in due course to reflect that. So just a little look then about how offsetting's previously been used. Some of you might be aware of the decision of the Secretary of State in the White House farm appeal. That was back in 2013, and it was the first time that the Secretary of State accepted offsetting to deal with habitat loss for a species where it couldn't actually be delivered on site. So it was ground nesting curlew. They reside in agricultural habitat. It was a farmer's field and it was all being turned into housing. So there was no opportunity as part of the scheme itself to create any habitat for those particular species. So the Secretary of State basically accepted that the appellant would buy credits from the Environment Bank. And again, some of you might be aware of the Environment Bank, sort of one of the forerunners in terms of offering credits for offsetting. The Secretary of State decided that that approach would be something that was reasonably within the control of the appellant, and so it could be secured by way of a Section 106 obligation to deliver those offsets in due course. Obviously, in terms of what one might do in a scheme moving forward, it might be possible for you to provide your biodiversity net gain on site. It really depends how much land you've got, what habitats you're dealing with, and obviously all of those facts that are fact specific to the case. So in terms of where we are at the moment, local plan approaches are actually moving ahead of the Environment Bill. I'll come on to deal with the Environment Bill later, but it has been significantly delayed. In that stead, local authorities have stepped into the void and created a policy environment in some instances, which effectively requires mandatory net gain ahead of the legislative provisions in the Environment Bill. So first of all, we've got Warwickshire. We've got a local biodiversity metric tool being proposed there and used by Warwickshire County Council. Again, that raises an issue of which metric do you use? There's plenty to choose from even at the moment, and will that become even more complex as things develop? I'll come on to that a little bit more later. And then, of course, it's setting up a framework so that you can either secure an agreement directly with a third party, so someone who's going to provide credits to you, and then they provide the offsetting on the land that they control, or making financial contribution to Warwickshire County Council. And again, there's some concern at the moment about how those financial contributions are negotiated in terms of what is taken into account, how black and white does it have to be when you're using the metric. And again, I'll come on to some of those issues later. Another authority that's taken a bit of an early lead, although they haven't developed their own metric as yet, is Barnsley. The thing that I wanted to comment on here in particular, though, is the final bullet point on the slide. So they're actually going a step further than the framework at the moment. Their policy actually says development which will harm a biodiversity feature will not be permitted without mitigation or compensation measures. So that's quite an onerous test. Obviously, it goes beyond the significant harm test within the framework. So just another example that in some cases, local planning authorities are actually stealing a bit of a march on this. And finally, with Plymouth and South West Devon, they're looking for proportional biodiversity net gain. They're saying that it's going to depend on how big your site is, what the type of development is, what the impact of the development is. And so again, it's going to be quite fact specific. You're going to need some real specialist input from an ecologist who really knows their way around how to deal with biodiversity net gain and all of the things that come with that to negotiate this planning framework that many of the authorities are starting to develop. So touching briefly on the environment plan, the government's 25-year environment plan includes a commitment to create a nature recovery network. Now, what they're looking to do is effectively join up habitat across England. And again, this goes back to the fragmentation point, which was first picked up by the Lawson Review back in 2011. And sometimes it's quite surprising to see that we've waited this long for any sort of concrete proposals at national level to actually start to bring this forward. I mean, it's nearly 10 years ago. I remember everyone being quite excited about this at the time. I was in my relatively early years of practice. And obviously, you know, it's taken quite a while to get things moving in the right direction. So the idea is to create or restore 500,000 hectares of habitat outside of protected sites. So this is in addition to sites that have an actual statutory protection already. So obviously it's a big ambition, and there's a real question mark about how quickly that can actually be achieved. The Environment Bill is going to establish local nature recovery strategies to create and connect habitat and put that into spatial planning so that there's a statutory footing to require that those linkages to be brought forward and delivered. One of the issues, however, though, is that the bill proposes that this is going to be something that local authorities are responsible for. Now, we'll all be aware of the fact that local authorities have an awful lot on their plates, never mind the white paper on planning and how that might impact on their duties and the things that they have to grapple with through the development plan process. This will be an additional burden. There's obviously a question mark over funding at the moment. There's also a question over expertise. I mean, do they have the expertise to be able to deliver this? And at what speed can it be brought forward? There are 5 pilot studies that are currently underway to identify valuable sites for wildlife and restoration for nature. That's been put forward by DEFRA and Natural England at the moment. They're developing maps effectively. There's 5 pilot studies where they're looking to develop maps to demonstrate exactly where in a particular authority district the most valuable existing sites and habitats are actually located. So effectively, first step, can we get to a baseline position where we actually know where these things are and what state they're in? Once that exercise is done, it allows you to then identify the gaps and focus your intentions and all of your energy on the bits where you need to actually give them the most attention. One of the other things that they want to do is obviously consult widely with stakeholders to try and make sure that they do identify and agree the priorities for restoring nature in those particular areas. So again, it's a very big project, and we'll have to wait and see how that pans out. So moving on to the Environment Bill itself, as James already mentioned, I mean, the government has lauded this as the most ambitious environmental programme, but frankly, it's stuck. It's already been delayed significantly, and given what the government's currently got its hands full with, there isn't any indication at the moment when it will be moved forward. So, as James said, there is a real conflict in messaging here between the importance of driving forward an ambitious environmental programme and actually the time that the government is committing to this. Now, They might be forgiven for that at the moment, but it still leaves that situation where there's a tension between the two objectives. So it's not got past the first committee stage. That's where it's currently still at. What it's going to do is propose the amendment, as we mentioned earlier, to have a duty to enhance rather than just conserve biodiversity. It's also going to impose new requirements for mandatory biodiversity net gains. So this will apply in any development, whether or not there's a local planning authority development plan policy that requires it also. You'll have to deliver 10% net gain. What that means effectively is 110%. So you've got to keep the 100% of biodiversity value of the site that you're developing and then deliver 10% on top. One of the mechanisms that the Environment Bill is going to put on a statutory footing is the creation of compensatory habitat, so offsetting, but that's going to come with a 30-year maintenance requirement. Now that's quite new for a vast majority of the development industry. There will be people who are in the minerals industry who are used to seeing that on large quarrying sites where you've got 30-year restoration requirements. But for most developers in residential or employment, that's going to be something that is new, and there'll be question marks about how that can be delivered. As we've already mentioned, the system really seems to favour offsetting potentially, because that could be one of the easiest ways to deal with your biodiversity net gain. There's a suggestion that the 30-year requirement to manage or maintain can be dealt with by funding, but implementation is currently unclear. Who does the funding go to? How is delivery organised? Lots of questions there. We've also got a 2-year transition period once the bill comes into force before those net gains become mandatory. So again, a question mark really over the urgency that the government's committing to this. There will also be published guidance, we're told, in relation to the new measures, but at the moment, obviously, we're a little bit in the dark. We don't know whether or not some methods of calculating or achieving net gain are likely to be preferred over others. And I said that I would comment a little bit on the metric approach. As you've seen, we've got local metrics with Warwickshire. We've also got the DEFRA metrics, now version 2. I don't think it's gone live yet, but I'm sure Stephanie will tell me if it has. We've also got a British standard that's in the mix that's being worked up at the moment for biodiversity net gain and offsetting. There's also a question mark over what will the importance of local biodiversity action plans be in all of this. So is there going to be sort of a black and white application of a metric, or is there going to be some holistic approach that takes into account wider environmental strategies that basically apply in that particular area wherever your site is located? I guess in other ways you could say, well, is there going to be any common sense here, or is there going to be a sort of a blanket approach of a metric that you can, there's no flexibility from? My current experience at the moment is that there is some flexibility, certainly in the approach that local planning authorities are currently taking to this. They do seem to be willing to take a holistic approach. One of the things the metric does at the moment, the DEFRA metric, is it gives quite a lot of value to scrub habitat, both in terms of, you know, what's it worth if it's already on your site, and then what's it worth if you provide more. But actually, you know, it's not too difficult to see that scrub isn't always as good as trees. It's just that trees take longer to grow. So the metric gives it more weight. So there are those anomalies in the system. And once again, I think this really comes down to having an experienced ecologist to advise and get involved and give you the right advice early on. Just one final point to note on this slide. Of course, delivering biodiversity net gain will not take away your duties to deal with protected sites and protected species. So don't fall into that particular trap. Unfortunately, at the moment, you do still have to look after the newts. So just in terms of the application of biodiversity net gain, obviously one of the things to look out for if you're a developer is, have you got net gain built into your proposals? Is it inherent in the scheme that you're putting forward? If it is, make sure you bang the drum about it, because it can be a real benefit, especially ahead of a mandatory requirement. Secondly, in terms of longer term sites that are going through local plan allocation, for example, plan ahead. If you know you're going to have an impact and you can't manage your biodiversity net gain on site because it's relatively small, you don't have enough land, start to think about it now. And also that and the second point that I'm about to come on to, collect evidence at an early stage if you can about what the actual biodiversity value of your site is. If you don't have the evidence on your baseline, you're obviously going to start to struggle in terms of planning for a net gain. And if you've not taken that into account, for example, when you're dealing with your option agreements, you could find that the viability of the scheme is going to be affected by this potentially. So it's something to engage with early, get your experts in and get to the bottom of it, establish your baseline. In terms of the mechanisms that might be available to deliver net gain, obviously what we've got at the moment is things like Section 106 agreements. It's also possible to purchase credits. The system that's being proposed by the Environment Bill is trying to effectively create a market for that. We're expecting credits to be somewhere between £9,000 and £15,000, but there's no certainty on that at the moment. So that's something that we really need to keep an eye on and watch this space in terms of what those financial implications for your scheme might be. There's also a proposal in the Environment Bill for conservation covenants. So the idea is that these might be able to deliver net gain. It's a private covenant, a voluntary agreement between a landowner and a responsible body. The bill at the moment provides that a responsible body can be a local planning authority. They would have to apply. The other details of who are going to be responsible bodies will follow in secondary legislation. And they'll be able to bind successors in title and impose voluntary agreements effectively between a landowner and a responsible body to achieve a particular conservation purpose. One of the interesting things about this, though, is how it's going to be enforced and how that will work with the rest of the planning system. It's not entirely clear how all the pieces of the puzzle actually fit together on this. The bill at the moment suggests that the enforcing authority would be the originating authority for local land charges. Now, that might not be the same body that's actually got the benefit of the conservation covenant. And it's not clear at the moment how that body would then go to the originating authority and persuade the originating authority to take enforcement action through the civil courts for breach of covenant. So again, that's something that's relatively unclear at the moment. Finally then, I mean, there is some comment, of course, in the white paper that suggests that irrespective of the changes that are being proposed to the planning system, it's still going to include and require net gains to biodiversity. So again, consistent message there about the importance of biodiversity net gains. We've also got proposals about the replacement of Section 106 agreements with the infrastructure levy. At the moment, the detail really is very light on that. We're not quite sure how it's going to work. But also there's a real question mark about how it could actually deal with something that's not a financial obligation. So question mark there whether or not Section 106 agreements will still be required for delivering things like 30-year management plans. It seems likely to me at the moment. So just in summary then, what I would say is that there's clearly challenges ahead for developers, local planning authorities, and other stakeholders involved in the development system in terms of biodiversity net gain. We're still waiting for more detail when it comes to mandatory biodiversity net gain. The Environment Bill has to move forward for that to take effect, and at the moment there's very little information on when that might actually go ahead. But one thing in particular for developers to be aware of is that local planning authorities are stealing a march on this. As I said previously, they are going ahead with policy requirements, irrespective of the legislative position with the Environment Bill and whether or not there's statutory requirements to have 10% mandatory net gain come into effect. So it's going to be a key issue for development, irrespective of the Environment Bill. And obviously we can expect local authorities and objectors third parties were involved in developments on applications, or if we're looking at examination of local plans, to be picking up on this point and really hitting it home. So hopefully that was helpful. And Steph, I'll hand over to you.
Thanks very much, Alison. That's brilliant. And so a slight change of direction now, and we'll be talking more about, rather than the legal issue specifically, how we think that's going to impact on the environment, as I've been asked to give the practitioner's view. Now, if I can, there we go. Now, I hope I'm not being over dramatic about the practitioner's view here, and there's certainly good and bad in what's being proposed. But we do feel, I think, that we're standing on something of a cliff edge at the moment in terms of certainty of what the new regime will be and how we'll be operating, what our practice will be like. And that's not just bad for the environment, it's generally bad for the economy. So what I'm going to do today is I'm going to talk about, getting my slides to work first of all. I'm going to talk about the Greener UK Risk Tracker, which is a coalition of NGOs, of which my institute is part, who've been tracking what are the impacts likely to be on the environment of Brexit and the Environment Act and developments that have followed really since the referendum. And I'll just take you very briefly through their ratings for different topics. So first of all, air pollution, we rate that as high risk and increasing. Poor air quality is the largest environmental risk to public health in the UK, causes some 60,000 early deaths a year. And it's not just a health issue, obviously. Air pollution has implications for the natural environment, particularly sensitive habitats and things like lichens, and for the economy. In 2014, the EU started infraction proceedings against the UK for its failure to meet nitrogen targets. In 2018, the European Commission referred the UK to the Court of Justice, again over nitrogen, and there have been several private JRs for the same thing. The government's produced a range of air quality plans, but so far there's been little actual improvement in air quality. And this ongoing non-compliance looks set to continue, with a number of local authorities, including the 10 Greater Manchester councils, announcing delays to the implementation of their clean air zones. Now, the government's already indicated that it might change post-Brexit how air quality is monitored and assessed, and I quote here, to provide requirements that are more targeted and focused to UK needs. I think what the UK needs perhaps is clean air. So depending on the terms of any trade agreements reached, the UK could amend the standards or review any deadlines for meeting them. The Environment Bill coming into force a bit later than planned means that we're still unclear about what level of ambition the government will set around targets for particulate pollution. And there's been a reluctance to commit to a target in line with the World Health Organization's recommendations, despite our own evidence showing that it's technically feasible to achieve that by 2030. And with the Office for Environmental Protection still a bit of a riddle wrapped in a mystery inside an enigma, then all in all, it's hard to see how we'll have a workable system that doesn't regress from current standards in 3 months' time. Moving on then to chemicals. Again, this is rated as high and an increasing risk. In February this year, the government confirmed it wouldn't be seeking associate membership of the European Chemicals Agency, nor would it participate in the EU REACH regulatory framework for chemicals, because we wish to maintain the ability to diverge from EU chemical regulations, believing that the benefits of having control of our own laws outweigh the costs. On the basis of the current plans, a future independent UK regime, which is what we'll get in the event of a no deal, will be weaker than the high level of protection that the UK currently enjoys within the EU's gold standard system. While the UK's draft negotiating text hints that we might be interested in access to the European Chemical Agency's database, the EU is really quite unlikely to grant us that unless we agree to be aligned with REACH. So without access to the EU database, the UK is going to have very much less information to rely on, at least for a transition period of a couple of years, while we require companies to give us the relevant safety detail on their chemicals. And that lack of data could render us unable to implement or defend in court crucial controls on hazardous chemicals. There's a risk of becoming a dumping ground for chemicals that are banned or restricted in the EU. And of course, if we have a trade deal with countries with weaker regulatory systems like the US, That again might oblige the UK to allow in chemicals that are approved in the US but banned in the EU. Water, high risk, but slightly improving. The Environment Bill really is a key vehicle for securing improvements to the water environment and wetland habitats. And we're really quite positive about this area. There have been some really quite promising amendments, things like the timetable for dealing with environmentally damaging abstractions. And if any of those are accepted, then there's really some positive signs here. We also see the new Environmental Land Management Scheme as an opportunity to aid the creation and restoration of freshwater and wetland habitats and the delivery of nature-based solutions like natural flood management. In a recent speech, George Eustace said, "There's no point in leaving the EU to keep everything the same. The old model has not stopped the decline in our natural world. We must therefore challenge ourselves to think creatively, to innovate, and to consciously avoid clinging to processes and procedures just because they're familiar." I wouldn't disagree with the sentiment. So James Bevan, then, the Chief Executive of the Environment Agency, picked up the baton and in a speech in August said, "I'm all for doing innovative thinking, including about which bits of inherited EU law we should keep and which we should change." He went on to say that we should repeal the EU Floods Directive, a fairly innocuous piece of legislation that requires member states to carry out flood risk assessments, create maps of flood risk, and develop flood risk management plans, which we comply with perfectly well. He also then suggested reforming the Water Framework Directive. The Water Framework Directive is a landmark piece of legislation that sets very high standards and demanding deadlines. The final date for delivery is 2027 for improving water quality in rivers, lakes, estuaries, and groundwater. And it's driven a huge amount of the work that environmental practitioners have done in this area over the last 20 years. So James's issue with it appears to be that only 14% of rivers in England achieve Water Framework Directive good status because of the one out, all out principle. They fail on one of the 4 characteristics. And he would prefer to reform the directive so that rivers can pass if they're mostly good, presumably like the earth is mostly harmless. Sadly, the environment doesn't work like that. Different environmental goods and services, whether you can monetize them or not, simply aren't fungible. It's not okay to say the river's good because all of the other parameters are fine, except for the toxic levels of arsenic. Waste and resources, you're probably indicating that the trend here is a high and increasing risk. Back in 1975, for those of us who remember 1975, 90% of waste in the UK went to landfill. We do a lot of quarrying, we've got a lot of holes to fill. Whereas recycling was something of a national sport in many Northern European countries, with electricity and heat recovery linked to district heating. So the overall impact of 4 decades of EU waste policy in the UK has resulted in a reduction in landfilling, and a series of successive governments introduced landfill tax, the landfill tax escalator, and the lapse trading scheme to drive up the price of landfilling and make it less acceptable. We've had recycling move up from 10% to 40%. There's been a renaissance in energy from waste, and we've seen the growth of the circular economy concept. Now, the government has made the vital promise to match or exceed what the EU does on resources, but it is still at risk of falling behind, as evident before the coronavirus pandemic, and it's being exacerbated by it. Several sets of consultations were due in England this year and last. It's now unclear when or if they'll go ahead. The previous administration reversed its opposition to the EU's circular economy package, and we did indeed ratify it in July, but the headline targets were not transposed into UK law by the EU's deadline. However, although it was postponed for 6 months, the ban on plastic straws, stirrers and cotton buds has now come into effect. And the EU is still signalling its ambition to end the throwaway society through its single-use plastics directive and its circular economy action plan. That documents quite a high-level strategy, but it includes more ambitious measures for those promised or legislated for in the UK, including moves to ban built-in obsolescence, restrict single-use products and packaging, eliminate greenwashing, and legislate to ensure that people have the right to repair faulty products. So we think there's a lot happening in this area, and we're at risk of significant divergence from it in the UK. Fisheries, high risk, but a stable high risk. There's strong evidence really that European environmental legislation has been more effective than national measures for conserving marine habitats, and sustainable fisheries depend on a healthy marine environment. So, for example, under DEFRA's revised approach to managing fisheries in European marine sites, SACs, considerable areas of the seabed have been protected from bottom-towed fishing gear. Now, an important facet of that success is enforcement that's been upheld by the Court of Justice of the European Union. And there are concerns that without an enforcement body as effective and independent as that court, then some environmental legislation may be weakened. On a more positive note, Brexit could provide an opportunity to improve the management of marine protected areas in the UK offshore zone. That's from 12 to 200 miles from the coast. In the past, management of those areas had to be agreed with other EU states, which resulted in quite slow progress and sometimes very weak measures. But the UK has just published a review it commissioned from the former Fisheries Minister Richard Bainton, which makes proposals for upgrading some of the existing marine protected areas into highly protected marine areas as part of the government's 25-year environment plan. And this will be a real step forward in recovering marine ecosystems. Climate, high risk and still the same. It's welcomed, obviously, that the Prime Minister's promised a green economic recovery from coronavirus. And I guess as environment practitioners, we'll be looking to see the government's fiscal announcements matching that ambition and matching the ambition of the EU stimulus package centred around the Green Deal. The UK's decision to put climate into a separate agreement to the main EU-UK free trade agreement risks making climate look like a second order of concern at what's quite a crucial stage in the negotiations, and also that it could create diplomatic friction ahead of the COP26 next year. In not cooperating with the EU on wider Paris Agreement emission goals for 2030, the UK government's missing the chance to support a more ambitious EU-wide short-term commitment, which could be crucial to a successful COP next year. In negotiations, the EU and UK still agree on the need to cooperate on cross-border energy trading and are committed to trying to link the UK into the EU emissions trading scheme, and an agreed deal would keep wholesale energy prices down and ensure consistent carbon pricing across the channel. The recently released plans for the UK's standalone emissions trading scheme suggest it could have a tighter emissions cap, albeit not quite as tight as the Committee on Climate Change would recommend. There are no guarantees, however, that the UK government will continue to keep step with the EU across other climate-related policies. Farming and land use. So again, high risk, definitely seeing the pattern now, and the same. The Agriculture Bill returned to Parliament with the principle of public money for public goods at its core. And this will see farmers paid for providing goods the market can't, such as healthier habitats and cleaner water. And the government deserves congratulations for its consistently strong vision for farming reform, though there are still questions over the future level of funding and the baseline from which future regulations will be set. The new framework for legally binding targets in the Environment Bill will be useful here, provided that consequent targets are strong, adequately enforced and supported in delivery. And funding and capacity for enforcing environmental targets and laws has dropped markedly in recent years. Import standards for food products really continue to dominate the wider discussions over the future of agriculture. Despite the promising no compromise on environmental, animal welfare and food standards, ministers are still to put such commitments in legislation. Neil Parish's amendment on behalf of the EFRA committee was defeated. Ministers reportedly told the BBC that legal guarantees were more suited to the trade bill, but then the next reading of the trade bill was open and closed without the mention of standards. This right to diverge, to be exercised now or in the future, appears to be at the core of government decision-making on agriculture. Ministers have mooted a dual tariff plan that would place high import duties on products that fall short of UK standards, and this would work for governments committed to high standards but leave the door open for future changes and future governments to change their mind. Aside from the immediate animal welfare concerns at borders, the potential effects of no deal would include high export tariffs into the EU market for agri-foods and an increase in lower quality food imports under quickly signed trade agreements. This raises significant concerns around deregulation in the UK as farmers are forced to compete with food produced to lower standards, which would cast doubt on the success of voluntary environmental standards and possibly the take-up of ELMs. And then finally, it may come as no surprise to see that nature protection is also rated as high risk. Despite the commitments to maintain protections at least as strong as those which apply to EU member states, the government's launched a number of deregulation initiatives that could see vital protections for nature lost or undermined, including the Reform and Regulation Initiative. The government's apparent reluctance to agree a deal with the EU based on non-regression on environmental standards is a significant cause for concern. The reintroduced Environment Bill remains weak in key areas, including a sufficiently robust Office for the Environment for Environmental Protection, and I don't think today's amendments that have been released will do anything to reassure us on that score. They include a power for the Secretary of State to issue guidance to the OEP regarding its enforcement policy. The government assures us that this does not constitute a power of direction over the OEP, and the Secretary of State will need to exercise this power consistently with their duty to have regard to the need to protect the OEP's independence. Protected site strategies will be introduced, which will offer better protection for sites for activities happening outside of those sites, which currently can be quite difficult to manage. So we can expect more schemes like the approach to nitrate credit trading, which was designed to unlock housing in the Solent. Species conservation strategies will also be introduced, and these are billed as a new mechanism to safeguard the future of particular species at greatest risk. And by undertaking surveying, planning, zoning and developing measures to mitigate for those species upfront and across a wide area, this approach seeks to secure local populations, reducing the need for reactive site-based assessments and delays for development. These strategies seem a measure designed to push the government's district-level licensing scheme for great crested newts, which has so far had quite a slow uptake from local authorities. And those amendments will also place a new duty on local planning authorities to cooperate with Natural England and other public bodies in the establishment and operation of those strategies. All volunteers, please take a step forward. So those are the 8 areas of policy concern, and as you can see, they're all still considered to be quite high risk. And comments lately from government around regulation and newt counting delays haven't done a great deal to reassure us. As an ecologist, I'm asked about great crested newts quite a lot, and the answer is normally, yes, haven't you got a lot on your site? Yes, they are declining in numbers, but yes, they genuinely do need our protection. It just happens that rather a lot of the world's population is located here in England. Boris's Build, Build, Build speech, as James already mentioned, scapegoated newts for delaying work. George Eustace's speech also talked about better protection for species that are characteristic of our country that the EU has sometimes overlooked, like water voles, red squirrels and hedgehogs. And I think what rings alarm bells for me here is the fundamental misunderstanding of the cross-border approach that's needed for species protection, including species that might not have featured in Wind in the Willows, but still necessarily form an essential part of our ecosystem. Mr. Eustace talked about the negative consequences of attempting to legislate for these matters at a supranational level, which leads to a culture where national governments can become reluctant for trying new things. You'll have to forgive me if I'm slightly nervous about what those new things might be. You know how in a Chekhov play, when you see a gun hanging on the wall, you know that in the next scene, someone's going to get shot. But amongst all of this doom and gloom, there are reasons to be cheerful. And here are a few of them that I'm just going to talk very quickly about. The forthcoming Environment Bill, Alison's already told us all about how the Environment Bill is going to mandate 10% biodiversity net gain. And I think that is a bit of a reason to be cheerful, because we know what the measure is. The metric will come out, I believe, in December now. We'll aggregate around a unified metric. We'll all understand what we've got to deliver, and we'll have the ability to do works off-site. And whilst some developers have had difficulties identifying off-site locations for works, I think that's going to become easier as a market in credits develops. But also, if you can do it off-site, then you probably haven't paid development prices for the land. And there's a huge benefit in doing that. There's a benefit to a developer. There's also a benefit to the natural environment, because we can aggregate all those small contributions together and actually contribute to to strategic rewilding projects, to the nature recovery network, and see added natural capital benefits like natural flood management or carbon management. Now, just when we've all got our heads around biodiversity net gain, we'll be moving on to environmental net gain, which is already committed to in the 25-year environment plan. And this really means taking your biodiversity net gain as a starting point and then adding on additional natural capital benefits. So before you say, oh no, not another initiative, one of the real benefits that we see for this within my profession is applying it not to the 6 or 7% of built land in the country, but applying it to the 70% of the country under farming management and seeing how we can improve a much wider scale, at a much wider scale. Elms, that I've already mentioned, is a bit of a flagship policy for the government, and we really do believe that in implementing elms properly, there is an excellent mechanism there to deliver some of the 25-year environment plan goals. And then finally, I'm trying not to look out of the window at the rain and be sad that I'm not now in Kunming, where I should be at the COP and looking at the post-2020 Global Biodiversity Framework. This sets out a theory of change about how nations around the world need to be looking at ecosystem restoration and making significant changes to how they do business. And the UK government has already indicated its willingness to sign up to this. So what might that theory of change look like if we're all going to live in harmony with nature? Well, it's a mainstreaming of biodiversity, both the assessment and protection of biodiversity, into all land use policy decisions. So rethinking how we produce food and how we manage our land at a national scale, reforming those incentives, integrating biodiversity properly into spatial planning, so we know what are the areas that are significant, that are perhaps inalienable in biodiversity terms. Reforming economic practices reforming economic sectors towards more sustainable practices, and really building capacity in this area. Alison's already touched on the fact that local authorities will struggle to cope with the demands of what's being introduced. And so finally then, what will a future look like under an independent UK signed up to the Global Biodiversity Framework post-2020? Well, we can see impacts for organisations having to report on their biodiversity and ecosystem service impacts. We can see policies on climate change and biodiversity coming together and actually making more coherent sense. And we see a mainstreaming of biodiversity assessment across our land use, such that 30% of land and sea would be under conservation measures and 10% strictly protected. And that's a policy that the government has already indicated its agreement with, although it has a little confusion at the moment about what constitutes biodiversity protection and what constitutes landscape protection. But I think that all in all, we have an opportunity to rethink the economic system as though the environment mattered. Now, that's all I wanted to say at this point. And I think we can just have time for some questions. If Alison and James, you can put your microphones back on, then I've got a number of questions here, and please feel free to add any more questions into the chat box now, and we'll answer as many as we can. So first of all, I've got one for James. Thank you for your discussion. Doesn't the current situation point up A, increasing divergence within the UK on the way environmental laws are to be addressed post-Brexit, and B, the hazards of this interim period before the public have really been able to address the level of environmental protections that they really want? James.
Yeah, I mean, I think I touched on very briefly at the end of my talk the risk about divergence within the UK on environmental law. I think that's a really big issue. It's something I've spoken on before as a separate topic. I mean, clearly EU law has been a unifying force as between the environmental standards that apply throughout the UK, and without it there is a massive gap, and something needs to fill it, because otherwise even in this environmental field it could undermine the internal market of the UK. So obviously, I mean, this is clearly going to be part of the debate that's going on about that internal market bill, etc. But there is an excellent paper that the Institute for Government have produced on devolution after Brexit, managing the environment, agriculture and fisheries, making some very sensible suggestions about kind of things that are going to be required in order to maintain consistency of environmental laws across the UK, like, for example, a joint ministerial committee, etc. The only problem is we're running quite short time to get all that in place, and that's why I think that the second part of that question, is there a particularly big risk in this interim period where we're going to, exit properly in January, and potentially all the provisions of legislation that's needed for that to happen and work well won't be in place. I mean, that is obviously a big risk. I think somebody else also raised, I think on a linked point, could some of the devolved administrations choose to carry on applying and legislating for EU law? And of course, I mean, the answer is subject to any bill or any agreements that might prevent that, yes. And Northern Ireland, if the protocol is followed, is going to have to follow more closely in a number of environmental areas, the EU, including on waste and chemicals. And so, one often sees those images of the border, down the RSC. But the Scottish government has made statements that they would like to carry on following EU law, and I think the Welsh government might do the same. In which case, you've got a divergence between England and the other countries. So there are some, truly massive issues around the internal UK impact, and at the moment, I don't think we've really even begun to get to grips with them.
Thank you, James. Alison, do you want to add anything?
I was just going to ask James a follow-up question, really. I mean, once people have got their heads around this, though, is there going to be a case of, well, the door's shut, but the horse has already bolted, in terms of, individuals? When we've got people like Fergal Sharkey, obviously there's been a lot of activism in terms of challenging authorities like the Environment Agency on environmental issues. Fergal Sharkey's just issued proceedings against the Environment Agency in failing to protect water quality. I mean, are people alive to this? Have they switched on, or is it just going to be a case of realising when it hits them?
I think people are alive to it. I mean, I think one of the questions that someone asked later was, apart from voting, how can people try to ensure that government does the right thing on environmental protection? And I mean, I guess the answer is judicial review is one answer to that, and we do have a very active set of NGOs and individuals who are prepared to litigate. Of course, where that immediately takes us to is the fact that the government's conducting its so-called independent review of judicial review, which, I mean, obviously, the panel is independent, but I suspect, what the government would like is less judicial review, and that would not be acceptable given where we're heading. But yeah, holding the government's feet to the fire, judicial review is clearly one of the ways to do that, clearly.
Thank you. I've got a question here. I think I'll ask both of you to give me an answer on it. Nutrient neutrality requirements are becoming a serious issue and a block on development. The Solent and the Somerset levels are two examples. How do you see this issue being dealt with post-January?
Well, I don't think there'll be a massive change overnight in terms of the issues, but I think this is one of those areas where one does hit the case law on certainty and what the level of certainty is that's required in order for development to happen. And I think that, potentially as our case law diverges, potentially as legislation is amended, there is a possibility that these things might become a little bit easier to overcome, which is the good news if you're the developer, I suppose. Obviously, people will be concerned about the level of protection, but I do think nutrient neutrality is one of these areas where the certainty level is a key question, and that may change.
Yeah, I mean, I think to add to that stuff, I think I go back to your point as well from your presentation about, nutrient levels being one of the biggest issues is regulating agriculture. when it comes to these sorts of issues with water quality and nitrates. So, if there is an opportunity to actually grapple with that, if we can get ahead of that before the EU does, for example, in practical terms, something that actually really works, then that might help, break the deadlock and make it more straightforward and actually solve the problem, rather than just, as James says, providing an opportunity for development to go ahead without actually solving the issue.
Yeah, okay. Alison, I have a question here. Why do you think the biodiversity net gain requirements in the Environment Bill exclude the development consent order regime? We like you to speculate.
Well, there's an easy answer. They want to make sure that they go ahead, and they don't want them to be troubled by it. I mean, that's the straightforward response, I'm afraid, there. I mean, the DCO process is supposed to be faster and quicker. And, there are, if you want to call them loopholes, you could call them loopholes, but there are many things that DCOs don't have to grapple with that development projects at a more local level do have to tackle and have to deal with. So like nuisance, for example. Yeah, that's a big issue, and obviously could have bigger consequences if more development gets put into the DCO category. There's been a lot of discussion over many years now about housing developments potentially going in, depending on the threshold of how big that development is. So, again, that is a mixed message and could be counterproductive to the overall objective.
Yeah, thank you very much. Okay, we've got time, I think, for a couple more questions. Do you consider it possible that the proposed changes to the planning system would have the effect of reducing the ability of local planning authorities to control negative environmental effects?
Well, I mean, potentially, yes. I mean, I think it's very hard to answer that question, though, based on what's in the white paper, because we just don't have the detail. And I think personally, I think there's some good and bad ideas in that white paper, although quite a lot of them are, or to call them half-baked is probably being a little bit generous, but that needs to be worked up. And my main worry is not about there being reform and change, but it being rushed through with undue haste and without people thinking about the implications of all of this. So potentially, yes. I mean, it comes back to the mixed messaging, doesn't it? I mean, green Brexit versus cut the red tape. I mean, you can't do both. And at some point, you have to come to a conclusion about what you want as a government. And you can use the rhetoric of both, but you can't actually enact legislation that does both, because they are contrary. So, at some point, they're going to have to reconcile that.
Yeah, I agree, absolutely. I mean, there is a lot of blue sky thinking in the white paper for planning reform, and it's really not clear how that might happen. But I think one of the issues I see is that obviously we know at the moment, in terms of allocations, the level of scrutiny and examination of plan level is pretty rudimentary, quite frankly. And if you're going to be looking at giving a particular site a permission in principle through that system, then without an absolute wholesale reform of how that's done and the amount of work that would have to go into assessing the environmental impacts of developments at that early stage before they get an allocation in the development plan, then it's almost inevitable that some environmental impacts will be missed.
Yeah. Okay, thank you. And then finally, I have a question. James, you've commented mainly on bad EU case law that ought to be challenged under our new post-departure domestic powers, but presumably there are lots of good cases that might also be the subject of challenge.
Yeah, I mean, I picked my three bugbears really in terms of European court cases. But yeah, I mean, I agree. There's plenty of good jurisprudence from the European Court. Yes, there are opportunities for people to challenge those in a way that hasn't existed up until now. I mean, the only thing I would say is that if the government follows through and applies both the test to both the Supreme Court and the Court of Appeal, that it's got to decide whether it would depart from that case law on the same basis it would decide to depart from their own decisions, or the Supreme Court would depart from it won't be a really regular occurrence that the courts depart. It will be relatively rare, I think. It's a relatively high test for departure. The reason I picked the bad ones is I think those are the ones that could go, because, I mean, take into environmental Brussels, I mean, frankly, from what the Supreme Court said in HS2, were that same Supreme Court, and obviously it wouldn't be the same Supreme Court now, but were that same Supreme Court to have the option of departing from inter-environmental Brussels, they would definitely have done it, because they believed it to be completely wrong, and obviously it was completely wrong. But I think it will be much harder to persuade them in many other areas that it's the right thing to do to make that move, given the test and how high it's set. So yeah, it's a concern, and I think, you know, it's a concern that the good case law can be attacked and challenged, and there's always a risk, you know, if there is mitigation. But I think probably it won't be happening every day. We won't see a court on the Supreme Court every day.
Thank you. Thanks, James. Alison, I don't know if you've got any particular favourite piece of EU case law that you'd hate to see go in this way?
Not in particular, Steph, but I think that the bigger point for me is about the actual statute, you know, the directives that provide us with the platform. And I think the bigger risk is not will we lose some of the jurisprudence, but actually, you know, are we going to lose the legislative framework, and is the government going to roll back on that? And leave people who want to challenge decisions with nowhere to go by amendments to that statutory framework. So that's the bigger risk for me.
Yeah, absolutely. Well, thank you. I think we probably need to leave it there. Thank you very much to our excellent legal speakers this morning. Thank you all very much for joining us and listening in. I'm sorry if we didn't get to absolutely all of your questions. We did have quite a lot come through. And I hope you found it a very useful morning session. Thank you very much.
Thanks, Steph.
Thank you.